All right. Good morning, everybody. Thank you for coming to the House Judiciary Committee. Madam Clerk, will you please call the roll?
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter.
Present.
Hope. Arbit.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel. Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. I will now take a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. Those are now adopted. And today, folks, we are entering week 2 of guardianship. Last week, we had a very good overview of how guardianship works here in Michigan and sometimes how it does not work, and what we as a legislative body can do to cut down on fraud and abuse and also provide resources and assistance to those who are both under a guardianship or conservatorship, as well as to the people who are providing those services. We are going to have a discussion today on some proposed policies contained within 5 bills, and I want to be clear, the bills are not yet finalized. We are going to hear briefly from some of the bill sponsors, including ourselves. Following that, our Attorney General, Dana Nessel, will speak. Thank you for being here today. And we have multiple experts from the Elder Abuse Task Force that are going to give their perspective on what they have observed, what they have learned, and what policy changes they are recommending and why. The Elder Abuse Task Force is comprised of more than 55 organizations from public, private, and nonprofit sectors. There are more than 100 members divided into 9 committees that have worked diligently to accomplish 3 different sets of initiatives. I encourage everybody to explore their website to learn more about their work. Today and next week, we not only are we taking testimony, I expect we will have additional information in the following weeks to come as we are awaiting substitute bills. But we will today have an opportunity to get feedback from members of the committee as well as other important stakeholders so that we can craft the best policies possible. The House Bills 4909 through 4912 as well as 5047 are needed to ensure that guardianship and conservatorship are used to combat and not enable elder abuse. I further note that Representative Kofia's bill, which creates the Office of the State Guardian, will ideally be a place where both professional and lay guardians can go to for resources and help. To the committee, I note that while the bill sponsors will be available for questions, some questions may be better geared towards the experts that will speak after us. Also sitting up here with us is Representative Wozniak. And while many of us here on Judiciary are licensed attorneys, Representative Wozniak actually practices in this area, and we appreciate the work that he has done over the years. And we also have Mr. Scott Teeter, who is now leading the Elder Abuse Task Force, and prior to him, Judge Carl Marlinga put in a substantial amount of work. And Judge Marlinga has moved on to another endeavor, but we are very grateful to him for all of his efforts, which are reflecting in the evolving policies and bills before us today. Also, we have an organization, the Michigan Guardianship Association, which plays a very vital role in this area. And one of the biggest issues that has not yet been resolved, which is payment for professional guardianship. And that is not currently reflected in this package. I'm saying this as a preemptory measure because this is something that we are all trying to work on and untangle. Over the years, the Michigan Guardianship Association has been involved with this issue, and despite some recent speed bumps, their input has been very valuable, and I look forward to continue discussions with them and hope to integrate their suggestions either into this package or a separate piece of legislation at a later date. So last term, we did tackle guardianship, and they went through the Judiciary Committee, and I know that Representative Filler, who is with us today, is one of the bill sponsors and has, over the last several years, been part of this movement to improve guardianship here in Michigan, and I'm happy to continue this work alongside of him. This is a bipartisan package. It is a clear example of how government can be an instrument of good. that we can work together across party lines to care for our most vulnerable residents and provide the resources people need to protect and care for their loved ones. Due to a number of people that are lined up today to testify, we are not going to be able to hear from everyone. Anybody who does submit a card, if there is not time to hear you speak today, please note that your testimony will be recorded and reflected in the minutes, and I hope that at a future hearing date, we will be able to hear from you depending on time constraints. The committee is now going to go at ease.
The Judiciary Committee will come back to order.
Thank you, Madam Chair. My bill in the package is House Bill 4909, and to be clear, this bill was drafted prior to the last bill in the package. So the language that you see right now in 4909 is going to be definitely different from the final product, as the language pertaining to certification will be removed or altered, as that is now within the purview of a different bill. What will remain are guidelines for judges regarding the priority of appointment for guardians. This bill will also outline factors for courts to use in deciding who will be suitable to serve as a guardian. This includes a person's willingness and ability to serve as a guardian or a conservator, and they do provide the necessary guardrails for judges to use in order to ensure that the best person who is now going to be in charge of another person's life will be able to do so adequately. And that is the basic nuts and bolts of my bill. I'm now going to turn it over to Representative Sergalou, who will talk about her bill.
Thank you, Representative Breen, and thank you to the committee members. I'm here to testify on my bill, House Bill 4910, which modifies the duties and obligations of guardians and conservators by amending the Estates and Protected Individuals Code. This bill would revise a guardian ad litem, also known as GAL's duties, and a guardian's duties, along with establishing a procedure for removing an individual from their permanent residence. So the bill updates statutory duties of guardians and requirements related to filing a written report. If an individual is alleged to be incapacitated, a guardian will gather information as required by law, interview the individual in person at their location and out of the presence of any interested person, identify whether that individual plans to retain legal counsel or wants legal counsel appointed. And if appointed for an individual alleged to be incapacitated or a legally incapacitated individual, a guardian ad litem must file a written report with the court and in the form required by SCAO, along with many more requirements. This bill also requires guardians and conservators to create an inventory of a ward's possessions and file receipts for expenditures over $1,000. It requires guardians and conservators to keep an incapacitated ward in their permanent residence, if at all possible. It prohibits the moving of a ward out of state without a court order. And it provides visitation duties on a guardian so that we can ensure that guardians are meeting in person or having contact at regular intervals with their wards. It also identifies or requires guardians to identify items of personal or sentimental value. And it adds the duty to allow interested persons to review proofs of income and disbursement at a time reasonably convenient to the guardian and interested persons. It actually has a lot more duties and requirements even than these. This is a very lengthy, comprehensive bill, and it's designed to keep our individuals who are part of this system both safe and well cared for, and just ensure that their interests are being met. And of course, we'll have more detailed explanation of all of this from our experts as we go forward. Thank you.
Thank you, Chair. I guess the first thing I want to mention is, and I don't want this to get lost as we talk about the details of the bills, guardians are good, and guardians have a really hard job, and it doesn't pay very well. And we just have to acknowledge the difficulty of that job, while at the same time acknowledging that a few bad actors have really done damage to vulnerable adults. And so the more common sense guardrails that we put around the system, the more vulnerable or elderly folks we protect. And so I really just want to keep that as an overview as we delve into the details. House Bill 4911 is mine. And 4 things: amends EPIC to require the court to set an initial hearing after a petition is filed to allow for meaningful preparation. What does that actually mean? It gives the court a little bit of time to see if a family member is there to serve as a guardian, and if the facts are all there as we delve into the guardianship process. You don't want this to be a rush process. You want families to be involved. So that's the purpose of that piece of my legislation. Number 2, it allows the court to dismiss a guardianship or conservatorship appointment proceeding if it cannot be shown that the individual is incapacitated. And that's common sense to me. Some individuals actually don't need a guardian, so let's not force them through the process. Number 3, allows the court to stay proceedings to explore alternatives to guardianship. Again, helping with the decision-making phase. And then number 4, sets procedures for the appointment of an emergency guardian, and more protection for the ward is what's happening there, just to make sure there's someone there helping them make decisions, because they can't make decisions on their own. And so that's what my bill, House Bill 4911, does.
Thank you, Representative Filler. Representative Borton was unable to join us today to testify as to his bill, but what his bill does is it revises the process of appointing a temporary guardian and removing a conservator. The court may appoint a temporary guardian of no more than 6 months if it finds that an incapacitated individual's welfare requires immediate action and a guardian has not yet been appointed, or an appointed guardian is not effectively performing their duties. It outlines the procedure for appointing a temporary guardian, and the temporary guardian is entitled to the care and custody of the ward and will make reports as the court requires. So they have authority, and the authority of a permanent guardian is previously appointed while another person might be suspended. And then a temporary guardian may be removed at any time. There is a similar process for conservators, and these requests can also be made by another interested party by an informal letter to the court. And I will now turn it over to Representative Kofia to talk about the big bill.
Thank you, Rep. Breen. Thank you, Madam Chair, to the Vice Chairs and members of the committee for taking up my bipartisan bill, House Bill 5047, and this total bipartisan package with Rep. Filler, Cernoglu, Borton, and Chair Breen. My bill and each of the bills in this package, as was said at the outset of this meeting, are based on the recommendations from the Attorney General's Elder Abuse Task Force, with the wide and deep expertise and several years of work getting us to this point. And as my colleague Rep. Filler said, we are very appreciative of the many guardians and conservators who genuinely act in the best interest of their vulnerable wards, fellow Michiganders, and they do this important and, yes, sometimes difficult work. Sadly, as the Elder Abuse Task Force has found in many news stories, including in my district in northern Michigan, news stories have reinforced this is not always the case. There are instances in which we are realizing we really need to safeguard vulnerable adults and seniors from bad actors who enact financial abuse and other types of abuse. So my bill, House Bill 5047, would create an Office of State Guardian, or OSG, housed within MDHHS to help oversee these efforts. The Office of State Guardian would be overseen by a board and run on a day-to-day basis by an executive director and other support staff within the office. We are in active conversations with the Elder Abuse Task Force leadership and MDHHS Appropriations Chair to hammer out specifics for the staffing requirements. And we do expect to have specifics for you as a committee to consider in the near future. OSG would be tasked with a range of responsibilities aimed to provide both support and compliance for guardians and conservators, as well as funding for professional guardians who serve indigent protected individuals. Some of the key responsibilities, my bill is also lengthy and a lot of detail, but I'll highlight a few of the key responsibilities the Office of State Guardian would include: certification and registry. OSG will be responsible for setting minimum standards for the certification of professional guardians and conservators. Individuals who meet these standards will be maintained on the Michigan Professional Guardian and Conservator Certification Registry. And certification, as described in this legislation, is based on the National Center for Guardian Certification process. It requires individuals to submit periodic background checks and disclosure requirements. Two other key points before I wrap up: investigation and compliance. The concept is that this Office of State Guardian would be responsible for receiving complaints and investigating them against guardians and conservators who are believed to be enacting financial or other abuses on their wards. The goal is that the OSG would then work with the Attorney General's office on complaints that did involve improper criminal conduct. Education and information. The OSG will also be responsible for the publication of educational materials that support and assist lay guardians and conservators to help them better meet their fiduciary duties. OSG will collect data and statistics regarding the guardian conservatorship systems and report this data to the legislature, we the legislature, as well as the Supreme Court. So that is sort of a synopsis. Thank you for your time, and we're now going to turn it over to several experts who are here to speak in more detail and answer questions.
We do have a question from Fink.
Thank you. And thanks for your presentation this morning. I received a copy of a letter addressed to Chair Breen from Kent County Probate Court, the chief judge there, and I think it's also signed by a second one. And at least the members of the committee appear to have been CC'd on it. So I wonder if at least Representative Cerniglu might also have been familiarized with the concerns that these judges brought forward. There's a number of them, but the most fundamental one, I guess I'd say, appears to be that this package would introduce what they characterize as a extremely cumbersome, even a dangerous level of extra responsibility for courts. The reason that it really got my attention is Kent County is, I think, the fourth largest county in our state, certainly has greater resources than most of the counties in our state do, and if they're concerned with the number of judges they have, the amount of support staff, and the budget that they presumably have, it greatly concerns me that counties like the ones I represent, Lenawee, Hillsdale, and Branch, would have at least this level of concern about the implementation of this package. So my question is, I guess, twofold. One is, are you familiar with the concerns raised by these judges? And secondly, what about even smaller counties where resources are stretched further already?
Thank you, Representative Fink, and I am familiar with the concerns, and I'm sure we are all eager, as well as members of the Elder Abuse Task Force, to work with judges to address and alleviate these concerns. I also note that we do have a commission, and we did address as far as this heavy burden on the courts by adding a judge in Kent County. I expect that bill's going to get through all the way, so we will be able to add some support to Kent County on the whole. As far as the caseloads and the heavy work, we also have a specific group that studies this, and they make recommendations to the legislature as to whether or not additional judgeships will be needed in particular areas. So I hope that we can work through these concerns, and we have been able to address many concerns that have been brought to us already by a variety of different judges. And I just remain optimistic that we'll be able to provide the resources that they will need in order to help enact some of these guardrails and ensure that our vulnerable citizens are protected.
Chair, with your permission, I have not seen the letter, so I guess I'd have to take a look about which were their specific concerns that we need to be aware of, specifics with the bill. So I'd like to know about that. And the second part is we did make pretty massive changes from the initial bill that was introduced last term. The bill that was voted out of Judiciary was a product of negotiations and back and forth with the probate judges and probate attorneys who are on the ground floor of many of these cases and have a very high volume. So I guess I'd have to see the specifics.
Sure, yeah, of course. We can provide you a letter. I'll just mention very quickly, Rep. Filler, that
Thank
they do raise concerns with the introduced versions of House Bill 4909, including that the limitation on the delegation authority and the requirement for certification, concerns about 4910 requiring virtual visits in addition to in-person quarterly visits, requiring guardians to identify and compile a list of reasonable number of personal items, and all of the follow-on to that. Essentially all of the additional requirements in 4910, as well as raising concerns relating to the temporary guardianship.
You've listed some of my favorite parts of the bill, and some of the exact reasons we think needed guardrails are there. But we look forward to learning a little bit more.
And to be clear, it's not obvious to me from this letter that the judges are saying that that it would be bad so much as it wouldn't be doable.
Okay, thank you, Chair.
We have another question from Oatman.
Thank you, Madam Chair, and thank you, representatives, for being here. Rep. Bean, I have a question regarding your bill. I believe it's 4909. I was just wondering, could you elaborate on the provisions related to visitations with the ward and I guess how they differ from current regulations?
So as far as requiring visitation, I believe the way we have it right now is they must first visit with their ward if they're an appointed professional guardian within a month. And then after that, I believe it's every 3 months, and it can be virtual. Some guardians have wards all over the state, depending on those individual circumstances. But what we don't want is for somebody to be appointed a guardian, and it may not even be a full guardianship. It could be a partial. So meaning that somebody might be able to make their own financial decisions, but they can't necessarily remember to take their medication in the morning. So what we don't want to run into is a situation where a guardian does not visit or attend to the daily needs of their wards. So we don't want to make it overly burdensome. This particularly pertains to the professional guardians, because a lot of our guardians are lay, where they have to move their mother home into their own house. They might be visiting with their loved one every single day, but the professional guardians are stretched a little thin. But we do need them to regularly check in with the people that they are protecting and make sure that those basic needs are being met.
Just for my own clarity here, so currently they must visit a ward within 3 months of their appointment. And not less than within 3 months after each previous visit. And this bill would strike that language, and we would revert to what exactly?
I believe it is an initial visit, and then it's either once a month or once every 3 months. It has to be a virtual visit.
Okay, thank you.
And that was, if you don't mind, Chair, that was sort of a compromise that was set last year because the original recommendation, and again, a lot of this is built on compromise, was very aggressive, something like one visit every month or something like that. And folks reached out and said, we just don't think that's realistic. And so the compromise was technology or ability to visit via technology, and also just less visits. So
Thank you.
We kind of went right down the middle.
Gotcha. Don't remember asking that question, but thank you.
I have a question from Johnson.
Thank you, Chair. For House Bill 4912, having a temporary guardian take over for the initial guardian, how does that work so that there's not overlap and the initial one doesn't know that there's a temporary guardian and two are trying to act as guardian? How does that work itself out?
I'm going to defer to one of our experts, and again, to the committee. I know these are a lot of technical questions, but that is something that I believe one of our experts can address because that gets very, very specific. And we certainly don't want somebody to go without their care and basic needs, but there are situations where fraud or abuse is found, and the person that is charged with guardianship is at fault. And so therefore, they would need to make sure that somebody else has the ability to step in and fill that void on an emergency basis.
Well, thank you. As a social worker, I've had a lot of clients who required appointment of a guardian, and they had a lot of different concerns. I think this package covers various number of issues and is addressing those concerns. So I want to personally thank the sponsors for bringing this to the forefront and bringing it to our attention and presenting on those topics, those concerns. So the committee will go at ease.
We are back, and I know that we are joined by our esteemed Attorney General, Dana Nessel, and her merry men, who are going to give us some additional information.
All right. Well, thank you so much, Chair Breen, Vice Chairs Edwards and Fink, and members of the committee. And my merry men are Aaron Van Langenfeld, who's policy for my office, also serves as a prosecutor there, and Scott Teeter, who's the head of the Elder Abuse Task Force and also the division chief for financial crimes in our department. As you know, I'm here to testify in support of House Bills 4909 to 4912. For over 20 years in this state, we've been carefully evaluating these problems, but we've done absolutely nothing about them. In 1998, the Michigan Supreme Court created a task force to improve the guardianship system, and that resulted in EPIC, our current statute. But other strongly recommended measures in the report were not ever implemented, and that included legislation to address the inadequacy of poor recognition of existing statutory provisions for medical treatment decisions, that guardian ad litems who are appointed on behalf of an individual in a judicial proceeding should include information evaluating the functional capacity of their investigations and their reports regarding the protected person. That minimum ethical standards for professional guardians and professional conservators should be promulgated and enforced. That courts should increase the recruitment and training of volunteer guardians, and more guardians who are funded and monitored by state agencies should be provided as guardians of last resort. But despite these very strong recommendations, nothing happened. Then, in 2007, Governor Granholm created another task force that investigated elder abuse and released further recommendations. And some of those things involved defining rights for incapacitated persons, understanding that once a person has a guardian appointed for them, they lose their rights to make even basic decisions, medical and financial. That it's important when appointing guardians for people who are experiencing diminished capacity that, whatever decisions they can make are still preserved in some manner. That it was imperative to implement recommendations of the 1998 Michigan Supreme Court task force on guardianships and conservatorships. And that there's a need to identify resources and support the implementation of the recommendations of the 1998 Supreme Court Guardianship Task Force, and that implementation of these recommendations would minimize or prevent abuse and neglect by guardians. But again, what happened? Nothing. Absolutely nothing. Now, I testified before this very committee in 2021 on this package of bills, and we made some great success on the Financial Exploitation Act, which has helped prevent seniors from having their life savings gutted by bad actors. I go all over the state talking to people, and I know that that law is working. And I know due to the work of this committee and this body that there are countless seniors all over the state of Michigan that never lost their life savings because of the work that was done here. And we also created the standard vulnerable adult incident report form that helps law enforcement report and investigate elder abuse. So we have made progress in some ways, but we still have not yet touched the guardianship piece really in any meaningful way whatsoever. And it is at long last time to do something. And I'm confident that together we can pass this legislative packet and protect our seniors and most vulnerable adults in a bipartisan fashion. So how did we come up with these recommendations? Well, as noted by the chair in 2019, I partnered with the Michigan Supreme Court to create the Elder Abuse Task Force to effect systemic change within the elder justice system. And also as noted, that task force consists of over 55 different senior advocacy organizations, private, public, nonprofit sectors with the goal of combating elder abuse, and also, I would add, a bipartisan coalition of legislators from both the House and the Senate. And the task force, we immediately set to having, we hosted a listening tour, which consisted of over a dozen stops. We traveled over 2,600 miles of the state. We heard firsthand over and over again the horror stories of problems people had in probate court with the guardianship system. And, wherever we went, didn't matter what part of the state we were in, didn't matter what group we were talking to, we heard the same types of problems. Problems like wholly unqualified people who were serving as guardians, emergency guardians that were being appointed without any hearings at all, family members being denied guardian appointments without any explanation by the court, guardian ad litem reports being inadequate for the court to make a proper decision, guardians moving someone from their home, sticking them in a nursing home, cleaning out their house, and throwing away all of their belongings, tossing them in a dumpster, and then immediately putting the house up for sale with no appraisal. As a result of this listening tour, the task force started, as you know, three slates of initiatives with actions that we wanted to accomplish on behalf of older and vulnerable adults in Michigan. So we've been working now for over 4 years to address these complaints. This package of bills was introduced last term again and ultimately didn't make it through the entirety of the legislative process, but we remain optimistic that this will be our year, that we finally deliver legislative solutions to the many problems I just listed and sign these provisions into law. Now, my office routinely handles cases involving court-ordered guardians that truly highlight the need for change. And these are just a few that are very recent. A Scottsville woman who was found guilty just this month by a Mason County jury of all 11 charged counts for abusing her authority as a guardian and embezzling from 10 vulnerable adults that she was appointed to protect, all of them developmentally disabled. A Saginaw woman who was sentenced this month to serve 15 months in the Michigan Department of Corrections on account of embezzlement of over $100,000 or more, and agreed to a restitution order of almost $200,000 from her own mother's estate. A Macomb County woman who was bound over on 18 felony counts for allegedly stealing tens of thousands of dollars from 2 vulnerable adults who were also developmentally disabled. And we allege that she used her position to steal over $100,000 from the victims, which she used to pay personal bills and funnel money to her family's companies. I'm about to turn this over to Scott Teeter. Again, Scott is also a former Cass County prosecutor who brings decades of experience and knowledge to these issues, in addition, of course, his work now on the task force and in our financial crimes division, and supervising the department's elder abuse unit. And most importantly, his division investigates and prosecutes many cases like the ones that I just mentioned involving elderly and vulnerable victims. But just before I turn things over to him, speaking of people most impacted by the legislation, those advocates that I told you about who initiated this work back in 1998, they all have something in common. They all died waiting for these changes to be made into law. And this is truly our opportunity for them to make things right. We don't need to have another generation of people die waiting to have improvements be made that will significantly change and improve the lives of seniors in the state of Michigan and those of us who love them. So thank you so much for having us here today. I'm going to turn things over to Scott.
Thank you, Attorney General Nessel, and thank you for your work. There are heartbreaking stories, absolutely horrific stories about what has happened to people, and I know that we have people in this room who have lost family members, and I'm looking at you, and I'm sorry we cannot enact these changes in time to help you and your families. We do have a question from Representative Fink, but I'm also going to gently remind the committee that there will be an opportunity next week to continue this testimony. And if you can wait till then, please do. But if you have something to ask today, obviously bring it forward. So, Representative Fink.
Yeah, I can be quick. I already referred to these communications we got from the Kent County judges. One of the issues that they raised, though, I think relates to concerns that have been presented by other people, and it's the first thing that comes to mind for me. And again, it doesn't necessarily take issue with identifying problems or inefficiencies or concerns within our current guardianship administration to say that some of the burdens imposed here could create a barrier to entry in a field where we already have shortages. And so again, as I think about the differences in the counties in our state, there's counties of more than 1 million people. There are counties of fewer than 10,000 people. There are Democrat-leaning counties, Republican-leaning counties. There are counties on, heavily in manufacturing, and then there are ag communities. As I think about the smaller counties, if there's a barrier to entry that the Kent County judges are so worried about, it just makes me worry we wouldn't have any professional guardians. So, what's your basic response to that issue?
Well, thank you for that question, Representative Fink. First of all, let me say this, and I think this has gone unaddressed. The concerns that you heard about in that letter, one of the things that these bills would do would be actually to create fewer guardianships. That's one of the things that we're talking about. So when you're talking about, okay, there'll be more requirements for the court when you have the guardianship paperwork that is filed, we're going to have far fewer of them if these bills pass. So I think that's something, we have, considering what our population is, and Scott can probably speak further about this, we have so many more full guardianships than I think virtually any other state in the country. So yes, if you were to look at the numbers now, of course, that would be a lot of additional work. But we're talking about creating fewer guardianships because so many full guardianships are just simply not needed. So I think that's something important to look at. The other thing I want to say is this. I think that, again, and I mean to say nothing that would be disparaging in any way, shape, or form of any of our probate court judges around the state. But anytime that you create more requirements and you add to the workload of an individual, I think you're going to get pushback, no matter how necessary and important those changes are and those additional requirements are. And I can recall having a sit down. This was my first year in office, first year on the task force. This is 2019. And I was at the Supreme Court. There were 3 Supreme Court judges in my presence. And we also had the entirety, I think, of the executive board of the probate court judges. And they were making the same, complaints, concerns as what you saw in that letter. And so I went down the list of all the things that we wanted to do. And I said, okay, even if we address this concern or that concern, which of these are you okay with? And I remember at the end of the day, the then president of the Probate Judges Association said, none of them. And really, it struck me because I thought, well, what are we doing here if we're just saying, like, this is too hard, so let's not do anything? I know that a lot of what we're contemplating in these bills will add resources. And once we have some of these changes in place, certainly, there's no question that we are going to have to do things to accommodate the courts in the event that they need additional assistance. But I guess the point that I'm making to everybody here is the answer, the solution to these some estimated 73,000 incidences of elder abuse, neglect, and economic exploitation every year. The response to that should not be doing nothing. And again, these recommendations, these did not just fall out of the air. We're talking about decade after decade after decade of different task force, different groups, different senior advocacy organizations, bipartisan members of the legislature, all making the exact same recommendations. And so, again, we feel very confident that these will work, but we have to have people who are motivated to actually make sure that we change the law and put them into place. And we can address any and all other issues that come up as a result of it. But what we cannot do, what we must not do, is what all the many legislative bodies did that came before you, which was nothing.
Thank you. Just very briefly, I'd like to address a couple of the questions that were asked. The first one is, I've reviewed Judge Murkowski's letter. I met with Judge Murkowski and actually had him sit in on some of the meetings with the task force. And I have respect for the work that he does. I would analogize it to this. It's like staring through the peephole in a hotel door. The part of the hallway that you see, you're seeing accurately, but it's only a small part of the hallway. Judge Murkowski's point of reference is Kent County. And actually, if you look at the underpinnings of that letter, it is, we don't have a problem here, don't screw this up. And I agree. In fact, their system is in large part underwritten by their hospital that donates well over $100,000 every year to help pay for indigent guardian services. And he mentions that in the letter. Nobody else has that. What we're looking at is a way statewide to, in fact, mimic part of what he's talking about, which is how do we get guardians paid for the services that they render. 43% of the cases that public guardians handle are without compensation. The promise that we made to MGA when we started this whole thing was, first we need to make you a profession, and then we need to get you paid. But make you a profession means state oversight. It means education. It means background checks. It means posting a bond. It means all of the things that we would require other professionals to have. And that's what the Office of State Guardian is charged with doing. And I've been asked what requirements, very similar to what the National Guardian Association already requires, and most of the members of MGA already possess. So we're not talking about reinventing the wheel and making them jump through a whole bunch of additional hoops. It's basic stuff that says, okay, we're going to make sure you're not a criminal before we turn over somebody else's life into your hands. I don't think it's too much to ask that we have the same level of supervision for somebody who takes over another human being's life than we have for somebody who deals potatoes in the state of Michigan. That's a licensed profession in our state. And I have nothing against potato dealers. But I'm saying if you stack the two, this is a human being's life we're talking about. And so for that, Judge Murkowski makes a statement in his letter that I think is a bit telling. And it's paragraph 2 of the second page. I'm sorry, third page. It says 4910. This is as it relates to the requirement of documenting the personal and sentimental items and keeping a reasonable number of those. And his response was, this new requirement of questionable value towards would add a duty to identify, store, and safeguard property. Of questionable value towards? I guess that depends on if you're sitting behind a bench or it's all of your family photos that are thrown into the dumpster on whether or not it's a questionable value to the ward. I would argue it's the biggest value possession that they have. The other question was about visitation. It's pretty simple. Right now, guardians are required to visit every 3 months. I've gotten complaints where somebody asked, could somebody please tell me why my mom has gone without teeth for 5 months? And that's because the guardian only had to visit one time during that period of time. What we've asked is, again, you don't have to do in-person visits. Monthly visits either by telephone or Zoom, because we now figured out we have the technology to do that, and then still the one time per quarter in person. But how do you maintain control over and knowledge of another human being's life when you don't see them except for every 3 months? And everybody we've talked to, even the guardians have said, that part's not unreasonable, but we want to be paid for it. I agree. That's why we are looking at the Office of State Guardian. How do we get you paid? First, we got to get you qualified, and then we got to get you paid. So just some definition of terms. Guardian is a person, once the court makes the determination or is reviewing the determination on whether or not you're incapacitated, that you cannot make the decisions yourself because of physical disability, mental disability, any of those factors, intoxication, any of those, that they look at 2 categories. Guardian takes care of the person. So that's the ones we hear about where, I decide whether you live in your own house or I pull you out and put you in a nursing home or put you in a group home or put you somewhere else. But you no longer get to make that decision of who you visit, who visits you, and where you live, and any of your personal care. The conservator, they take control of your money. So you put those 2 together. The term civil death has been used to describe that because what that means is as a person, you no longer live. You don't have the right to make any of the decisions that any other human being has the right to make. So that's why when we talk about, well, do you need a lawyer? Do you need due process rights? Do you need some of these things? Because what we're talking about is legally killing you off, and somebody else is going to take control of your life. Don't we have to take every step to make sure we get that right? So 4909, certification. We've talked about that. Secondly, and we heard this complaint over and over and over, that I went in as a family member. I was going to serve as guardian. My brother, who I can't stand, wants to serve as a guardian. The judge said, I don't know, I can't sort this out. I'm just going to appoint a professional. First of all, that's not what the statute requires, but that's what's being done. Secondly is, I have a right to know why I didn't get picked. Why did that right get pulled away? And the fact that me and my brother can't get along because of the Christmas of 1999, is that really relevant to who gets to take care of mom? And more importantly is, this isn't an undue burden on the judge to go, well, it might be your 12 convictions for embezzlement that's holding up my decision to appoint you to represent your mom. Okay, reasonable minds could differ whether or not that's a good call, but I think we can go, okay, but at least put it on the record, because if I think it's wrong, it at least establishes a record I could file an appeal. We don't have that now. I just walk out going, I don't know, I didn't get picked, but I have no idea why. The other thing, delegation, our issue was if we're talking about certification and we're going to pick the person that we believe is not only trained but qualified to make the decisions to control another human being's life, then you don't get to delegate that to the secretary. That's not who we picked. That's not who we certified. And that's not who gets to make those calls. I don't think that's crazy. The other thing is expiration. Right now, we've described guardianship as a superhighway. Once you get on, there's no off-ramps. There's no way you get out of this until you die. And that's it. So 15 months after you appoint it, the court has to bring you in and going, okay, are we still where we're at? Because we've had people who had serious medical issues that temporarily rendered them incapacitated. They had strokes, they had, whatever. They were not able to make those decisions. They got better. But how do you get out? And the answer is you can't. And so this way, at least 15 months later, we're going to bring you back in and go, is that still the case? If it isn't, then let's get you out of here. Give you a power of attorney, somebody to make, take care of your finances or whatever assistance you need, but you don't need a guardianship. 4910, again, this talks about you're going to have a designated decision maker so that if I'm the person who's working your file, I'm the most familiar with you and your specific needs. It doesn't get rotated person after person after person after person in my office, so that when the nursing home calls or when somebody else calls and says, what do we do? I don't know. The answer is get a hold of the person who's appointed as the decision maker. The guardian ad litem, that's been described as the eyes and ears of the court. They basically do the investigation to give to the judge to say, hey, here's what's going on in this case. What we're asking, and we trust that if you give judges better information, you'll get better decisions. That's sort of what the system is built on. And so I've had judges tell me we get 3/4 of a page from the guardian ad litem that says nothing that will help me make the decision on whether or not this person needs a guardian or whether or not they need a limited guardian or they need a conservator. I'll also get reports that are 30 pages long, which is all about the Christmas of 1999 and 2004 and how much each family member hates each other, and still gives me nothing about making the decision, does this person need a guardian, do they need a limited guardian, or do they need a conservator, or do they need none of those things? You have to interview the alleged legally incapacitated person. Is that too much to ask? Then talk to me and tell me what's going on in your life. Can you do that? And if you can, then I get to put that in a report to go, hey, we had a pretty long conversation. They're okay about getting up in the morning, taking their meds, all that kind of stuff. Can't do the finances. That's just, they've lost that ability. Okay, then we need a conservator. Or maybe they need a power of attorney. Ask them if they want to attend the hearing. If you're going to take away my life, don't I get to say, can I be present while you do it? Determine if the alleged LIP has a power of attorney, patient advocate, payee, or trustee. We've had cases where they got petitioned into court for a guardian, and yet their elder law attorney had written up a power of attorney. And they picked who they wanted to make those decisions, and the court blew right by it. Well, as an elder law practitioner, then you sort of feel like you're lying to them, going, well, if you do these things ahead of time like we coach you to do, then that won't happen. Somebody else won't take control. So this way, the court will have it right in front of them in that guardian ad litem report going, yeah, I have somebody that I've picked to make those decisions. Maybe there's another expert, a social worker, a mental health professional, some other professional that could say, wait a minute, you don't need a guardian. What you need is this. You need somebody a nurse to come in and assist to make sure that you get your meds. Other than that, you can get up in the morning, kind of take care of things. Okay, well then let's get a nurse. If the guardianship were ordered, who would the person want to serve? Can't we just ask them? And if that person's a total loser, then we go, okay, I appreciate your opinion, but we're not going to pick that kid. But at least we asked. And then also, maybe I don't get along with this person. Well, that person may be the one who's trying to take over my finances and my life, and I don't want them to. But at least that's in front of the judge. And then do an estimate of the assets, and then one of the questions that came up over and over and over is, right now the court rule is you get it 24 hours in advance, that report from the guardian ad litem, and yet that's going to be the controlling report for the court. 24 hours? If I'm the lawyer for the person who's about to lose their entire life, 24 hours? This says 5 days. You file it 5 days so that I can take a look at it and go, wait a minute. Okay, I'm fascinated about the story about the Christmas of 1999, but there's some holes in this report, and I need to find out the answers. I have no time to do that. A right to an attorney. We as a society have determined that that's one of the most fundamental rights ever when you walk into a court. If you're a murderer or alleged murderer or alleged child molester, you have more rights than have if you're alleged to be a legally incapacitated person in this state. The court must appoint an attorney if the individual asks for one. If they object to the petition and say, I don't want a guardian, but I didn't even ask for a lawyer, you're going to get one. Why? Because that's how we work in an adversarial system. And third, maybe they don't know either of those, but the guardian ad litem goes, yeah, they need a lawyer. They can't make that call. I'm going to make that recommendation. And then all the way through, because see, the weird trap you get into is once the court determines that you lack capacity, then you don't have the authority to hire a lawyer anymore. But what if I figure out the one who's supposed to be representing me isn't doing a very good job and nobody's listening to me? Why shouldn't I still have the right to go, okay, I want a different lawyer? And I can go out and hire one. I have resources. And we talked about the visits by the guardian, personal property. I cannot tell you the number of horror stories that I've heard where it went just like the AG said. Court appointed a guardian. Guardian came in, said, you're going to a nursing home, and all the stuff in your house is going into this dumpster, and this house is going up for sale for your care. You don't get to do that anymore. We get a lawyer to represent you. If you're going to move me out of my house, I need a lawyer because that's my home. And if you're going to take all my stuff and throw it away, then don't I get to keep the family pictures? I can tell you, if you ask my mom what's the most valuable thing she possessed, it's not her house, and it's not her car. It's her pictures of my family, of my dad, his service picture. We can't figure out a way to save that? And in the judge's words, of questionable value to the warden? We can do better than that. We have to. A speedy trial, not less than 7 days after the initial hearing. That gives time for them to prepare, to get ready, to get an independent evaluation so that somebody can come in and say, okay, we've done an eval, and that eval will have some very specific things in it that will enable the court to make a better decision. It would include, it would be paid for by the state. It would be a physician or a mental health professional. It details how long they've known them, how long they met with them. And the reason for this is I have seen in files, literally, on a prescription pad, a doctor wrote, this person needs a guardian. And the judge acted on that. You killed off somebody's civil rights with a one-liner on a prescription pad with a signature I couldn't even read. An assessment of current supports to see, and again, ask, do they have a power of attorney? Do they have a patient advocate? Are there other support systems in place? I saw somebody pulled from their home and stuck in a nursing home who had over $1 million in the bank. They could have hired people to come in. They were never given that option. Clear and convincing evidence, that's not the preponderance of the evidence, which is the lowest standard in our law. It's a higher standard. Why? Because this is so important. We have to get it right. And at any time, the court can just stop and go, wait a minute, I need more information. Or, wait a minute, I think there are alternatives. Does this person have somebody who's willing to serve as a patient advocate to make medical decisions? Do they have somebody who's willing to serve as a power of attorney to make financial decisions? Then you don't need the court to kill them off. We got people. And again, we talked about a court-appointed attorney. If the guardian files to permanently remove somebody from their home or to move to a new permanent resident, you don't get to yank me out of my house if I don't have a lawyer. That's got to be one of those basic civil rights, isn't it? It's not now, but it should be. Emergency petition, we got into a big discussion about this because what happens is on Friday afternoon when the hospitals decided that you're, either through with your care and they want you out, but they can't find anybody to take you, or you're unconscious because of a car accident, we can't give you medical treatment, we ram through an emergency petition, does not require notice to anybody, doesn't require a lawyer, and end up you're in the guardianship system. Okay, the person that drafted and ran our subcommittee on this very issue was Judge Tomlinson, who was former president of the Michigan Probate Judges Association. And they still didn't agree with him. But what he said was, okay, emergency should mean emergency. If we don't act, they can't drill a hole in your head to relieve the pressure and you're going to be dead before we get to a hearing. That's an emergency. But once we do that, we have to circle back right away to go, okay, now you're not going to die on the table, and let's get you back in the court and give you the rights that you're entitled to. And that expires within 28 days, and you get one extension. So it doesn't get to go on and on and on and on and on before we come back in and have a hearing. 4912, the big thing between a temporary guardian and conservator is, again, if sometimes while the petition's pending, there's some stuff that blows up that requires immediate care, it gives the court an authority to make a temporary appointment. Doesn't mean that you're done. It just means somebody who can step in and make sure that you get the medical treatment that you may require or take care of, any immediate needs that you have while we're still fighting whether or not you need a guardian. With a conservator, it just expands the right for other people to challenge whether or not you need a conservator. So the person can challenge, or any interested person can go, wait a minute, we have a power of attorney and we're doing fine. We don't need a conservator, or we need something else, a rep payee for your Social Security, but we don't need a court-ordered conservator. Office of State Guardian, again, this is pivotal to this whole move because, again, it deals with certification and registry. So we make this guardians for the first time ever in the state of Michigan that you're now qualified to perform the duties that we're requiring you to do, not just that you know the judge. Because that's all that's required right now. And secondly is there is no clearinghouse for complaints against guardians. Judges rely on what's called a notice and object system. And what that means is if I don't think the guardian is doing a good job, I can file a petition to challenge them and say, I need another guardian. Well, if you're not a lawyer, no, you can't. I mean, I can give you the form. You don't know how to do that. You could talk to an elder law attorney right now and say, what would it cost me to have you prepare an evidentiary hearing and object to the guardian and either have them removed or have no guardian at all? That's 10 grand up front. And so I hear over and over and over from family members who go, okay, well then how does this stop? Because not only I don't have the money to do that, but even if I did, the guardian is going to have a court-appointed lawyer and the two of them are going to pull the money out of mom's money to fight me. That's how it works. So that's why notice and object doesn't work. We have the same issue with regard to accountings. You ask Judge Murkowski and you ask any other probate judge, and if they tell you the truth, they will tell you it is not my responsibility to question those accountings. That's the other party's responsibility. And I said, well, Judge, I'm pretty sure when we passed Epic in '99, they thought that's what you were going to do. And they said, well, nobody sent me any people to do it. We don't do that. I rely on other parties to file those objections. Okay, if I can hire a lawyer to file those objections, that's a viable system. If I can't, then nothing happens. I had one case I wanted to review for criminal prosecution. Came out of the west side of the state. 5 years in a row, they billed the estate, the guardian did, for $50,000 per year for remodel of a 90-year-old's home. And the judge signed off on it. I can't criminally prosecute somebody when the judge said it was okay. It's not okay. But there was nobody to challenge because nobody had the money to do it. The Office of State Guardian could take that complaint. They could then ship it to the Attorney General's office. We would do the review. If it was criminal, it would go that way. If it's you're just a lousy guardian, it would go the other way. And we could then bring them before the Office of State Guardian, have a guardian hearing and go, you know what, you're a lousy guardian. Not only a lousy guardian in this case, you're a lousy guardian in every case. And we want to remove your certification. One of the things that's lacking right now is there's no coordination between counties. So I can be a total screw-up as a guardian in Oakland County, and if the judge pulls me off those cases, I can walk right over to Macomb County or Wayne and start all over. And we don't have a system to stop that. The Office of State Guardian will stop that. The other thing is we got to get these folks paid. And we have modeled the Office of State Guardian off of the Michigan Indigent Defense Commission. Because what we found was, after 10 years of study, is that a county-by-county approach funded locally to represent people in criminal cases fundamentally violated their civil rights. Well, what do we have here? The only difference is these people didn't commit a crime. They got old and frail. That's the only difference. And in that situation, we have to step in and go, okay, in order to protect the civil rights that we hold so valuable, we have to develop a statewide system. And that's what we're proposing. The AG referenced this before. Our goal is the system is not sustainable in its present form. So when you hear from anybody that says we don't need to do anything, they're wrong. They're wrong because the system is starting to break down under its own weight, and the weight's going to go up. By 2030, in Michigan, there will be 2 million people over the age of 65. We have over 33,000 guardianships right now. That number is anticipated to jump to 50. If we don't fix it now, we'll wait till it blows up. Because we should have done it 25 years ago when they said, fix it now. But we kicked the can down the road. Surrogate consent statute, if you polled your constituents, I would bet 80% of them believe this is the law right now. Is that if my mom is in an accident and she can't consent to medical treatment, they'll call me and I can. That's not true. In the state of Michigan, that's not the law. They'll run down and get an emergency guardianship and I won't have any say at all. Really? 33 other states. This is not like we're doing crazy stuff. 33 other states already have this, It's amazing to me that Michigan doesn't, but we need to fix that. We need to have it so that, okay, who's next in line? Can we treat your mom? Can we treat your wife? Of course. That's ridiculous. So that's coming. That will reduce the number of guardianships. It will reduce the number of emergency guardianships. Until that's done, though, we got to fix the system that we have. The power of attorney statute, the House passed it by an overwhelming majority, and then it's sitting. This is, again, one of those mechanisms where if you have a power of attorney, you don't end up in probate court in a guardianship. Those numbers go down. Lastly, before I came over here, we have in our lobby a freedom shrine. In it hangs the Declaration of Independence. And I reread, we hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness. And there's no qualifiers in there unless you get old, frail, or you're disabled. Thank you.
Well, great, Scott. Now you made me cry. So,
Thank you very much. We have several people who are lined up to speak after this. I know they're asked to keep their testimony to about 3 minutes. If we get to you, fantastic. If not, we will be asking you to come back next week. However, Representative Fink, you said you have a super, super, super brief question.
I mean, for me. Yeah, I mean, the essential question is, I get what you're saying about like needing to appoint attorneys. I thought that in some other legislation we did this year where we allow courts to suspend people's civil rights without having an attorney present. I think that's a pretty serious challenge. So I appreciate that in this case you're raising that issue. But on this barrier to entry question, just tell me if you can do it, quickly enough for Chair Breen. Why this certification first and then payment? It seems to me like you could take an entire set of objections off the table if we just do payment first, because what we're saying is everybody agrees that the payment is an issue.
Sure. Good question. What we want to do, there's language at the beginning of 4909 to tie bar that together so that they will happen at the same time. It's just that when we drafted 4909, OSG wasn't done yet. Now that it's done, we're going to go back, change the language in 4909 to connect those two. And the reason why is because if we came to you and said, okay, we need millions of dollars to fund this for people that we have no idea who they are, what their background is, what their qualifications are, you would think we're crazy. So what we can come to them and say, we're going to standardize this profession, we're going to raise the level of professionalism, and then we're going to come back to you and say, okay, this is the money that we need to properly compensate those people for the work that they do. Because they are professionals, they should be treated as professionals, and they should be supervised as professionals.
So I guess just to be clear, are you saying that in your ideal world, these additional obligations would happen at the same time that the funding issue is addressed?
Yes. And one of the things that we've talked about with OSG is that the certification requirement would not go in for 2 years to give the system a chance. Because I understand what Judge Murkowski's saying. If I said you got to be certified tomorrow, everybody drops out. Well, we don't want that. We want to give them time to gear up for this change, and at the same time, when we start publicizing, you will get paid for the work that you do. We'll end up with more guardians, not less. Okay? Any other questions?
No, thank you so much. Appreciate your testimony. I'm going to call now on Mr. Christopher Smith from the Elder Abuse Task Force, and while I wait for him to come up, I'm going to very quickly read in some cards. Supporting the bills, 4909, 4912, not wishing to testify, Jason Lakowski of AARP of Michigan. Supporting the entire package, Todd Tennis, not wishing to speak, from the Alzheimer's Association. Supporting the entire package, opposing the entire package, not wishing to speak, Mr. Bob Kennedy from the Michigan Guardianship Association. Thank you, Mr. Smith.
Thank you, Chairman. Thank you, Chairman Breen. My name is Christopher Smith. I am an attorney in private practice specializing in elder law and probate. And I was asked to serve on the Elder Abuse Task Force 4.5 years ago when I was chair of the Elder Law and Disability Rights section of the State Bar of Michigan. Today I speak to you as a private attorney and as a volunteer member of the task force. I also, as part of the task force, chaired our efforts to promote the Uniform Power of Attorney Act, which, thanks to Representative Hope and Representative Wozniak, is a key part of this. It gets to the issue of trying to reduce guardianship and was part of our effort to connect all these issues together. I have joked that my role in the task force is my Energizer bunny. It keeps going, and I give credit to the Attorney General's office, my tireless colleagues, including you, who have heard this over 2 sessions, and members of the legislature who have turned this into a relentless pursuit to finally make real, meaningful change. I mean, to put it in perspective, when I first attended my first task force meeting, took my infant son to his first month of daycare. Today, I took him to his first month of kindergarten. And I have to say, and I don't know if Representative Wozniak feels the same way, but as a private attorney, you feel this push and pull with this legislation that you guys are bringing here very much. My attorney colleagues, my friends who serve as guardians, and the judges, as Representative Fink has shown, that I appear in front of every day, have strong opinions. And on the flip side, my clients, mainly individuals with disabilities and older adults, are sending letters to you saying that this doesn't go far enough. And so I really feel when I saw Representative Filler up here saying, like, this is a compromise bill, and as being a part of it for 4.5 months, I can assure you that is very much the case. This task force has spent thousands of hours to put this legislation before you and has heard you from every interest group that wanted to talk, usually multiple meetings. And so what I think you have before you is a rigorously vetted, well-balanced proposal on a topic in which action needs to be done. And what I don't think you've heard the perspective of yet today is, in another hat that I wear as the co-chair of the Public Policy Committee of the National Special Needs Alliance, is that, let me be clear, this conversation is not isolated. It's part of a national conversation going on right now in which there is a tidal wave pushing for a shift of old school guardianship to the concept of person-centered support and decision-making. And if we keep pushing this down the road, Michigan will fall behind. And I also say to you, I know this committee hears a lot of criminal legislation, and you're probably like, well, this isn't going to affect me. I'm not a criminal. That's not the case here, okay? Guardianship can affect any of us at any age. And what you need to look at this is saying, hey, from a person-first perspective, this could be me. And if that's the case, I think you'll find this hard to argue against. 2 decades have passed since I attended my first day of law school. And I got to tell you, I still get nervous every time I appear in front of a new probate court. Imagine appearing in front of a probate court for the very first time without that legal background. And then picture, as Scott said up here, a guardian ad litem or an adult protective service worker who's sitting down with you, both strangers, and in the process of talking to you, you think they're an advocate, but really they're writing a report on you that is going to be the basis of the rest of your life. And imagine a doctor you've never met. I mean, we have doctors that we worked decades with, right? Or hopefully, that also holds the pen that writes our future in a 15-minute consultation. And then there's, as Scott said, the financial gut punch. If you get behind in this process in the guardianship proceeding, you're at the position where you're going to have to shell out tens of thousands of dollars of your own money to hire a private attorney, hopefully a good one like Representative Wozniak, who makes sure your case is fully heard. I mean, that is a crazy system. So I hear Representative Filler, and I just want to shake my head when he says this legislation is pure common sense. Who among us wouldn't want the right to cross-examine those with writing life-changing reports about us? And who wouldn't want a real medical evaluation? And if you were assigned a guardian, wouldn't you expect your choice to be heard first unless there's good reasons otherwise? And wouldn't you want a voice before being yanked out of your home? And wouldn't you want safeguards to protect your life savings and even that personal property? So I very much acknowledge and respect the need for judicial efficiency. And I commend the guardians who are probably listening to this and are my true friends, and they deserve fair compensation. But we can't lose sight of the basic human decency and fairness that should underpin our legal system. So in conclusion, I urge you to read these bills and ask, what would I want in this situation? And I'm confident you'll find that these are the bare minimum protections that anyone would expect. And in that context, I advocate for your passage of this crucial legislation. Thank you.
Thank you, Mr. Smith. Michelle Roberts, if you are able to, I'm sorry, Representative Johnson has a question for Mr. Smith?
Real quick, what's the thought process behind co-guardians?
Whether they're a good idea or not. I always have concerns when there are too many cooks in the kitchen. It can cause problems. It can cause conflict. But in the right situation, it's a good idea. It's really a fact-based question that just depends. Sometimes it works and sometimes it doesn't.
Thank you, Representative Johnson. Thank you, Mr. Smith. Michelle Roberts, if you are able to keep your testimony to 4 minutes, I'd love to hear from you.
I'll do my best. Good morning. Good morning, Chairwoman Breen and other members of the House Committee today. My name is Michelle Roberts. I'm the Executive Director with Disability Rights Michigan. Disability Rights Michigan is a private nonprofit, nonpartisan protection and advocacy program mandated to serve Michigan's disability community. We are a law firm that provides free information and referral, conducts investigations, and provides advocacy and direct legal representation to individuals of all ages, all types of disabilities throughout our state. Disability Rights Michigan is honored to be an appointed member of the Elder Abuse Task Force since it began in 2019. We're pleased to support the work of the task force and the legislation to reform the guardianship system. The proposed changes will stop unnecessary guardianships, ensure people subjected to petitions are seen, heard, and afforded the choice, dignity, and respect they deserve, and ensure that those subjected to a guardianship do not lose their human and civil rights, their personal property, their homes, or their lives. Disability Rights Michigan receives thousands of calls each year from individuals with disabilities seeking assistance. Our clients call to report abuse, neglect, and financial exploitation by their guardians, and for assistance to terminate an unnecessary or overly restrictive guardianship order. While the task force focuses on eliminating elder-related abuses, the reforms that are before this committee would benefit all Michigan citizens. Any one of us could be subject to a guardianship petition if we acquire a disability, we're seriously injured in an accident, or we become vulnerable as we age. The gaps and drawbacks within the current system are complex, and this legislation lays the critical foundation we need to build additional reforms going forward. So this legislation is not intended to fix everything, but without these changes, we will fix nothing. Sincere consideration of alternatives must be given so supported decision-making and other legitimate and preferred options are utilized. Limits on caseloads and guardian certification must be instituted so citizens can get their needs met by someone who knows their wishes and preferences. Guardians appointed to serve 600 or more individuals simultaneously cannot reasonably know them, know what's best for them, or even recognize them when they delegate those duties to other people within their offices. I want to just quickly share 2 common cases that we see at my office at Disability Rights Michigan. First, an individual with mental health needs is appointed a guardian after not consistently taking her medication. The client is moved from her home, which she owns, moved into a facility. The few belongings that the guardian gathers are placed in garbage bags and sent along with her to the place that's intended to be her new home. The woman requests some of her personal artifacts, things that are important to her, photos, her ID, her birth certificate, and her mother's ashes. The guardian didn't want to drive several hours to bring those items to her and felt it was cost prohibitive to mail them. And since she had no intention of the individual returning to the community, she didn't figure she needed her personal items, so she threw them all away. Another example is a woman who had financial assets was petitioned by her son for guardianship. The son alleged she had dementia and was unable to handle her finances or take care of herself. None of this was verified, and in fact, none of it was true. Nonetheless, the son was appointed as her full guardian. He immediately moved into her home, took away her driver's license, her keys, her phone, and didn't allow her to communicate with anyone, including her sister, who she routinely visited and spoke to every day on the phone. The guardian stole her money, physically and mentally abused her, and isolated her from everyone for well over a year. Despite the sister and others trying to intervene and get help, no one could penetrate the controlling guardian's version of the story. As more people started to question what was going on, the guardian became more abusive and beat her so severely she needed to be airlifted for life-saving treatment. This legislation would have prevented both of these instances. Our citizens deserve better, and we need your support to make these changes a reality. The legislation before you can and will protect Michigan residents, and most notably, our most vulnerable. Thank you for your time and consideration.
Thank you for everything you do, as well as for being succinct and to the point. Unfortunately, we're not going to have time for any additional testimony or questions. Looking at you, Representative Fink. I do very much look forward to these continued discussions. I'm going to quickly read in some cards and then wrap up. Opposing the bills, not wishing to speak, Anita Berman from the Guardian Assistance of Michigan. Opposing the bills, wishing to speak, however, we do not have time this week, Ruth Ann Jaquette of Mid-Michigan Guardianship Services. Opposing the bills as written and willing to work with the sponsor, to 4909 specifically, Genevieve Marnin of Right to Light of Michigan. And thank you for your conversation this morning. Neutral on the bills, wishing to speak again, sorry, we do not have time, Ms. Jody White. Neutral on the bills, Ms. Cynthia Mifsud. Wishing to speak again, unfortunately, we do not have time. Also on Zoom, opposing the bills are Shannon Tanis and Tom Howe. I would encourage people to pay attention to next week. We did not have time to hear today from Sally Pune, the Michigan Long-Term Care Ombudsman Program, Nicole Shannon, and Allison Herschel from the Michigan Elder Justice Initiative. I want to thank everybody for their patience. We are unfortunately going to be kicked out due to tax policy coming in, but this was very helpful. I thank the committee for their patience, and we have a lot of very good work, a lot of really, really good work ahead of us, and I'm looking forward to it. Thanks, everybody. We are adjourned.